Hi, and welcome to this latest immigration law update video. In this brief video, I want to look at a Home Office coronavirus concession that's contained within their policy document. The policy document is the family life as a partner and parent, private life and exceptional circumstances policy. The current version at the date I'm recording this is version 10, and that was published, as you'll see from my screen, on the 18th of August 2020. As with any video I do looking at Home Office policies in particular, do check for updates. The Home Office do regularly change and tweak their policies, so do check that this is the current version you're looking at. This policy, family life as a partner or parent, private life and exceptional circumstances, is a useful policy to actually be aware of and be familiar with. It's actually the policy that contains the Home Office stance on when it's reasonable for a qualifying child, that's a British or a 7-year child, to leave the United Kingdom. You'll see that's at page 50. It's also the policy that contains the Home Office private life policy, particularly with what are very significant obstacles to integration, and you'll see that around pages 58 through to 63 of the policy. But if you look at the very end, just before I get there, actually, you can also see their policy on Article 8 and what they think qualify as exceptional circumstances and unjustifiably harsh consequences. That's their consideration of Article 8 outside of the rules. But let's go to the end, and you'll see at the end there's coronavirus COVID-19 concessions. So let's click on that and see what it tells us. It says this: a commitment has been made to ensure family and private life applicants are not unduly affected by reasons beyond their control due to COVID-19. The pandemic may have caused disruption to travel plans, causing breaks in continuous lawful immigration status / residence requirements. So this concession from the Home Office is particularly directed at where there are issues in terms of residence requirements and a break in your lawful immigration status. So it goes on: due to the impact of COVID-19, some applicants seeking to start, extend or complete a route to settlement on the basis of family or private life may be unable to meet the immigration status / continuous residence eligibility requirements of Appendix FM due to COVID-19. This may be due to travel restrictions, closure or inaccessibility to a visa application centre or illness. So this is particularly looking at the immigration status requirements and the continuous residence eligibility requirements in Appendix FM. And you'll see there they say, ordinarily there is no flexibility for you to exercise discretion in allowing the lawful immigration status and continuous residence eligibility requirements to be met. So this is an instruction to caseworkers and say, normally you don't have any flexibility. But look, however, you may, so this is permissive, you may exercise discretion to allow an applicant to start, stay on, that's extend or apply for further leave, or complete a route to settlement despite them being in the UK as a visitor. That's where you can now switch from visitor status, or with leave of 6 months or less, in country or overseas for a short period of without leave, where it's shown that they were not able to travel or apply due to COVID between March and the 31st of August 2020. So if your leave has lapsed while you're out of the UK, or you're an overstayer for a short period in the UK, if it's because of COVID and because of this situation, they may be able to exercise discretion. It goes on to say you can disregard a short period of time spent overseas where leave to enter or remain expired, and an applicant could not return to the UK to renew their leave due to COVID-19, provided an applicant extends their leave and or makes an application for leave to enter as soon as practicable. So clients need to act as soon as practical. The break in continuous residence may be because the VAC was closed or inaccessible, and the applicant was unable to apply for further leave to enter where they should have been applying for leave to remain, or the applicant returned to the UK as a visitor or following a visa waiver or carrier waiver in order to complete an application for further leave once back in the UK. And then listen to this. In some cases, an applicant with leave applying for further leave or ready to apply for settlement may not have been able to travel back to the UK but instead was able to access a VAC to apply for indefinite leave. Appendix FM would not ordinarily allow for a period of leave to enter or remain, followed by another period of leave to enter in order to be eligible to apply for settlement after 5 years. However, where the application was made in order to maintain a continuous period of lawful residence, you may take that period of leave to enter into account. So you can apply from abroad where you'd normally have to apply in country if you were stuck there, it seems to be saying. You may disregard a period leave outside the immigration rules granted by Border Force to allow an applicant to re-enter the UK following a period of being stranded overseas during COVID-19 when their leave expired between 1st March 2020 and 31st August 2020. So this is a particular COVID policy addressing problems with lawful immigration status and where you can switch where you otherwise wouldn't be able to, or particularly issues of breaks in lawful immigration status, particularly when you're stranded abroad, it would seem, and unable to travel due to COVID. But have a look at that, because that may assist you in making applications on behalf of your clients who are stuck in these situations and would otherwise face breaks in their residence. So have a look at this policy, which is page 94 of the Family Life as a Partner or Parent, Private Life in Exceptional Circumstances, and this is version 10 of the 18th of August 2020. I hope that's helpful to you. Thanks a lot.